This is a follow-up presentation that I gave a few months ago for this group on the Revolutionary FAR Overhaul. And while some of you may not have participated in that original presentation that I did by way of sort of introduction, I'm going to start at the very beginning. Can you guys hear me okay?
Yes, we can hear you.
Okay, good. I just want to make sure. I'm going to start where I started the prior presentation, go through sort of why we're here, why they're doing what they're doing, and the current status of where things are. And we're also going to talk about the most recent revisions to the FAR based upon this process that we've been going through with the administration. Okay, that's me. David already introduced me, so we can skip there. All right, so what we're going to be talking about today is sort of a big deal in the federal procurement world, which is where I spend most of my time. Back in April of this year, the president issued an executive order indicating the administration's desire to change how the government procures goods and services. There hasn't been a full-scale overhaul of the federal acquisition regulations since its inception in the 80s. So we're talking about 45 years since you've had any sort of a revision to it other than adding to it, which is actually one of the issues that was raised by the administration and cited as a reason for a need to scale it back to revise it. It had become very cumbersome particularly for those that aren't attorneys and not accustomed to understanding much of the legalese that was contained and still is contained in certain portions of the or in the FAR itself. Even as part of the overhaul, you have some of that, but certainly based upon the changes that we've seen some considerable lessening of that legalese and a simplification in the verbiage that's used and the size and breadth of what was a part of the FAR. So and this is sort of what I was alluding to as a basis for all of that, what's been done since April. And there's been a considerable amount of work that's been done since the executive order back in April. The point of it was to lessen the tremendous amount of verbiage in it. It's one of the reasons for it. You see 2,000 pages of complex regulations, and that's certainly what it had grown into over the years. The executive order that was issued wanted to bring the federal acquisition regulation back to its statutory roots, which effectively meant that anything that was not based in statute would be effectively removed unless it was essential to sound procurement. That's taken directly from the executive order, or necessary to protect economic or national security interests. Back at that time in April, when the executive order initially was issued, the big question was, okay, what does that really mean? Over the course of the months that followed, we've understood to a certain extent what the administration believes is essential to sound procurement, because now at this point, given where we are, and we'll talk about exactly where we are momentarily, what they believe is essential to sound procurement is effectively known at this point, because we're at the end of the initial phase of the rewrite that we're here to talk about. And we also have a better sense of what the administration feels is necessary to protect economic and national security interests, again, because of where we are in process. And we'll talk about some of that. Okay, so one of the questions that we had initially, and some of these slides go back a number of months. I left them in there purposely so that we can sort of see, okay, this is where we were. Now, what do we know? Okay, back at the time, there was a question of, okay, well, if something is not statutorily based, for example, many of the mandatory disclosure requirements that are in the FAR are not specifically statutorily based, will they survive the FAR? We now know, we're actually going to talk a little bit about this today, that the mandatory disclosure requirements are deemed essential by the administration and remain an essential part of the FAR. And that is now known to us based upon the most recent revisions that were just issued several weeks ago by FAR counsel. Another question by way of example here, economic price adjustment clauses. Are they something that will survive even though they're not statutorily based? The answer there also is yes. The economic price adjustment clauses that were found in the old version of the FAR survived. They continue to be used on a discretionary basis under the Revolutionary FAR Overhaul process, and the results that we've seen thus far are such that how that particular clause, for example, was used will continue to be used moving forward. Same with mandatory disclosures. So the lack of clarity that existed several months ago now has been provided by virtue of the changes that have been made. So as originally introduced, this was the time frame, and back in April, May of this year, there was a lot of question as to whether or not this time frame could be adhered to. Nothing like this had been undertaken in all the years that the FAR had been in existence, and many practitioners, myself included, wondered whether or not any of this could be remotely possible. Could it be done? And in fact, we are through the first three boxes as you sort of go from left to right. The challenge that you see there, the fourth box, is now sort of where we are. This sort of challenge that is now before the administration is not, can all of the changes that the administration desires progress consistent with this time frame? Now the question is going to be the notice and comment period, the rule writing process that is currently taking place now. And we'll talk about what that means momentarily. Can it be done such that all of the changes that we've seen over the course of the last 6 to 8 months are firmly in place sort of on a permanent basis? Okay, so for a regulatory change like this, the process must be for those that do this. I don't know if there are any lawyers on. This is not news to you, but for everybody else, in order to make a regulatory change like this, there needs to be notice and comment in the Federal Register. And normally when changes are made, regulatory changes are made, that's on the front end of any such change. Here, it's on the back end. It's a very strange sort of process, the way that this has happened. All of the changes as they've occurred have taken immediate effect for procurements that were issued following each one of these changes. The changes by law should have gone into effect. It's been a little hit or miss in terms of how contracting personnel have treated it, but from a procurement perspective, from a process perspective, the way that this has been occurring has been the changes are made, the changes are immediate, and the changes are subject to further changes based upon this rulemaking process that I'm speaking to now, and we're sort of in that stage of it. And we'll talk again a little bit more about that here momentarily. Following the executive order that I just made reference to in April, the following month, there was an OMB memoranda which set forth the process in terms of how all of these changes were going to take effect and how it was going to work. And that memoranda identified the fact that this was going to be a fast-paced set of changes, that anything that was not mandatory by statute, as I referred to a few moments ago, was going to be dropped from the FAR unless it was absolutely necessary. And for those provisions that were not statutory but were deemed essential, at least some of those would be dropped into buying guides and practitioner guides to assist contracting personnel and contractors as well in terms of what the expectations would be moving forward. So in certain instances, these buying guides, which are, we'll talk a little bit more about those momentarily, but these buying guides were to be designed and will still be designed to act as guidance for contracting personnel, but they're not mandatory. They're just simply guidance. And we'll talk a little bit more about that as we progress. But this memorandum was issued to serve as a way in which the process would be administered sort of moving forward. And it has been largely followed. As part of that memorandum, it identified two phases to the process. Phase one is what I just referred to, these immediate revisions, and they've been coming out on a rolling basis for months. And what the process has entailed is on a periodic basis, these changes that are being issued that are appearing on acquisition.gov. Okay, so if anybody wants to see what those changes look like, they go on to acquisition.gov. There's a landing page there. We're actually going to look at it momentarily so you can see what it looks like and find it yourself to the extent that you've not already done so and are curious about where these changes are and how they're being implemented. Okay, so all of this was occurring as part of the immediate revisions in phase one. The formal rulemaking piece, which I was just talking about, is identified in the May memorandum as phase two. At this juncture of the FAR changes, that's where we are. So consistent with the desired time frame, we're there. So what the administration wanted to do was over 6 months' time, between April and October, have revisions in place for all 52 parts of the FAR, eliminating portions of that 2,000 pages worth of text, reallocating provisions where the current administration believes they should be to the extent that movement as to, of some of this verbiage made sense, at least to the administration. All of that would be done by October. It's done. And now we are entering into the formal rulemaking process. Nothing has appeared in the Federal Register yet, but I expect at some point in the next several weeks, you're going to see some or all of these proposed changes in the Federal Register, and the administration will be seeking public comment on the changes sort of moving forward. All right, so that's where we are. As these changes have been rolling out, you've seen FAR Council issuing deviations to the FAR, and those deviations then have been pushed down to the various different agencies, and the agencies themselves have been issuing their own deviations to their individual regulatory provisions that mirror the FAR for the most part. Department of Defense, their deviations are probably the most different than any of the others, only because of statutory issues that are pertinent to them for the most part that would allow for changes down at the agency level, the individual agency level, which may differ or allowed to or permitted to differ from the FAR level, which would be sort of at the top. So you have agency regulations that are generally supposed to be consistent with the FAR itself, but can differ from time to time depending upon agency need and statutory requirements that are pertinent to each one of those agencies. And all of this has been happening all at the same time, right? So, and we'll take a look at that in a moment so you can see it. And here we go. So if you go to acquisition.gov, that's where the landing page is for all of these changes. So you'll see on acquisition.gov, right at the top, you'll see a button that'll click you through to what we see here. And you can click through and see the various different revisions that have taken place over the course of time. So if you continue to click through, for example, this is what you'll see. Now it's all of them. This particular screenshot was taken at a particular point in time where, and it's in order here, numerical order. Okay, so at this point, FAR Part 1 had been changed, FAR Part 6 had been changed, and you can click through and actually see what those changes look like on the landing page as you click through. They have useful links over on the right that will allow you to see other aspects of the changes that have taken place. and you can focus in on it, precisely, what changes might be important to you, depending upon what industry you're in or what type of work you do. Certain FAR provisions might be more important to you than others. There's a frequently asked questions button, which you see there, and you can click through that. It's all hypertext linked, and you can pick and choose exactly what's of interest to you as you click through. And as you further click through, so if we were, for example, here to click through from the page we were just on, FAR Part 11, which pertains to describing agency needs, you can see each one of the subparts of that particular FAR section, how they've been either moved, changed, altered. You see to the right, there's a practitioner album. Each provision has a practitioner album, and that practitioner album will show all of those provisions that have been removed, specifically removed from the prior version of the FAR. The additions aren't shown. You can see those by clicking through on your left in the individual subparts. And it's not as easy or as user-friendly, rather, as seeing what's been removed. But that's how you would understand, okay, this is what's in the FAR now, what's been actually removed, that's in the practitioner guide. Also in the practitioner guide, oftentimes, we'll talk about that as we go through the specific changes to the most recent portions of the FAR that have been updated. It will provide guidance to contracting personnel as part of the procurement process, and also provide guidance for contractors to the extent that they click through and want to understand what's being changed and why it's deemed important to both the public and to government. Okay, a little bit about how things have been moved and what some of these new guidance documents mean and how they're going to be used moving forward. We just talked about practitioner's album and practitioner guides. You also have companion guides. The FAR companion guides didn't start getting issued until very recently, about 6 weeks ago. And the companion guides are designed to assist government personnel specifically on how to conduct procurements at different stages of the procurements, whether it's at the pre-award stage, pre-solicitation stage, award phase, or post-award. And companion guides are exactly as they're identified. They're guides. They're not regulations themselves. From a attorney's perspective, from my perspective, what it likely will mean is that if there's anything that could potentially be protestable, for example, using something out of a companion guide would be something difficult to support as part of that process. So if it's in the regulation and there's some sort of a misuse of that regulation or ignoring of that regulation, that might be one thing. If it's something in a companion guide that, as a lawyer, I want them to use, or I hope that they use, that might not carry the day from a protest perspective. So, and there's an awful lot of that as a practitioner, as a public, that we're going to have to better understand as things move forward. But these companion guides, buyer guides, which have not been populated yet, you'll see those on acquisition.gov also. They have not yet been populated. The companion guides are, they're new. The practitioner albums, very helpful. And we're going to, again, talk about some of those based upon the most recent changes that have been made. But all of this is very, very different. So we're entering a new day as it pertains to the FAR and how the government buys goods and services. So it's important for everybody who operates within this space. Okay, so now let's get into some of the most recent changes. And this is the last batch of changes, as I alluded to, that have been made. We're at the end of the change process, at least as to phase one, which I just made reference to. And now we're entering into phase two. But let's talk about the final set of changes that have been made to that last set of FAR parts, some of which are pretty important, so that we can understand what's been happening, at least as it relates to these specific FAR parts. And a lot of what's been happening here has been consistent with the prior changes that have been made. So FAR Part 3, improper business practices and personal conflicts of interest. There have been, I wouldn't say significant changes to this part. This part is primarily driven by statutory provisions and the statutory aspects of the FAR, as we just discussed a little while ago, aren't touched so much. So whether it's the Procurement Integrity Act, Anti-Kickback Act, or whistleblower protections, as we see here, all of those continue to be discussed as part of FAR Part 3. And the idea here as part of FAR Part 3 is to protect the government and the public from improper business practices and conflicts of interest, and how to avoid those as part of the procurement process. Largely, what we're seeing here are language simplification issues. You've seen some reshuffling of how this particular provision is set forth, but not anything terribly substantive as far as the changes are concerned. You do see some of the provisions that have been removed and placed into either the practitioner album or the companion guide that we just made reference to. Some have been deleted as redundant. You see records regarding contingency fee violations, and that's been happening a lot as it relates to the most recent changes that have occurred. They've been, deleted as redundant oftentimes because what has been happening over the course of 45 years, there have been all of these additions and all these hypertext links for people like me, so I can find my way around and understand exactly what all the cross-referencing between FAR sections means, and as far as legal requirements and that sort of thing are concerned. That's what we've been, there've been more and more of that. And they, over the course of time, they've continued to add these cross-references. Well, now you're finding less and less of them as they delete redundant passages within the FAR. So it's a lot easier for me in particular, since I'm in there all the time, but maybe perhaps others that might be in the FAR also, it'll be easier for you to find your way around based upon changes like that. But as far as it relates to this particular FAR provision, not a lot of changes, again, primarily because substantive changes, primarily because of the statutory nature of this particular provision. What is interesting about this particular provision, if you go into the practitioner's guide, they have all sorts of helpful information as it relates to this particular provision and how to maintain procurement integrity. This little graphic that you see here on the screen was taken directly from the practitioner's guide. There's all sorts of guidance. There's a video that's been placed in the practitioner's guide, for example, a case study that's also been provided primarily to assist contracting personnel in making sure that they ferret out potential conflicts of interest and handle them properly as part of the procurement process. And so if you go into the practitioner's guide here as part of FAR Part 3, you can see how contracting personnel are being directed to deal with these sorts of issues. I mentioned at the outset of the discussion today, contractor disclosure obligations. Those obligations, while primarily not statutorily based, have survived as part of FAR Part 52, which is the contract supplement to FAR Part 3, but even beyond, and this is actually a substantive change and a pretty important one, I would say, even beyond the changes that have been made to contractor disclosure, the fact that it's been, and there have been some adjustments. Even if this FAR Part 52 section is not in your contract, if you have a contract with the government, the disclosure requirements themselves are still obligatory, even if that provision is not in your contract. So that is an important, subtle but important change. So anybody who's really interested in understanding the importance of these practitioner albums, I would say, go into FAR Part 3 and check out how the practitioner album is used in this particular case because it's indicative of how they've sort of been used elsewhere. Not always this extensive, but it'll give you a good sense of how how the administration has used practitioner albums to buttress the procurement, the changes that have been made in procurement and the guidance that's been given to contracting personnel in terms of how to appropriately perform it.
Ed, we have a question from
Oh, yeah,
Mike.
yeah, sure, please.
Mike is asking, what is the logic for deleting the whistleblower regulations? And he provides example of 52-203-15, the whistleblower protections under ARRA. It's deleted as obsolete.
Yeah, so that particular one, and that's a good question. That particular one relates to ERA, and that's the statutory requirements pertinent to ERA, which came about during the Obama administration. That statute has effectively ended, right? So there isn't anything left associated with ERA that would be applicable. And so as anything related to that, and there were whistleblower protections pertinent to ERA, they're deemed to be outdated or obsolete because the statute has effectively run its course and is effectively no longer in place. And so anything ERA related has been removed from, any reference to it has been removed from the FAR. So that's a good question. But if there's anything that's either identified as redundant or outdated, that sort of thing, as it relates to anything that might be statutory, that simply means, at least as it relates to these changes, it's either ERA related or it's just simply been uh, limited to wherever it has been, wherever it's identified elsewhere, right? So what they've been trying to do is keep the statutory provisions that are pertinent to a particular FAR section in that FAR section and limit it from sort of being referenced in all sorts of other sections of the FAR, unless it's necessary. There are times when, as part of the rewrite, FAR Council has deemed it necessary to have cross-referencing, but for the most part, as I alluded to a few moments ago, that cross-referencing isn't nearly as prevalent as it used to be. But that's a good question. That's a good question, and thank you for asking it. Let me go ahead. Sealed bidding, yeah. So with respect to sealed bidding, one of the changes that has been made here pertains to how it's organized. You see here FAR parts 14.1 through 4 now has this particular FAR section organized based upon the life cycle of procurement, and that change is consistent in many other changes that have been made to the FAR. So the procurement process has been rearranged in many respects to mirror the life cycle of a procurement. So you have pre-award, evaluation award, post-award, generally speaking, that you'll find in many of the changes to the FAR. The substantive aspects of each one of those, each FAR provision where these types of changes have been made haven't altered quite a bit, and where they have, we'll talk about them, at least as it relates to the changes here. But there has been a large-scale reorganization of that information, so it looks very, very different, but substantively, many times, you're not talking about wholesale, large substantive changes. As it relates to FAR Part 14, you don't have any large-scale substantive changes. There are organizational changes consistent to what we see here. Not anything terribly different. There has been some elimination of language that's in here, but mostly just because it's outdated. And you see reference to facsimile bids and bid envelopes and things of that nature. A lot of that has been eliminated. I don't know, does anybody use faxes anymore? I don't think so. Certainly the uh, FAR Council doesn't believe so. So FAR Council, as part of the rewrite, has eliminated much of the references to facsimiles, in fact, all of them, bid envelopes and things of that nature, and has modernized it to refer to electronic forms of bidding. And so you'll see changes pertinent to that, but not anything incredibly substantive as it relates to FAR Part 15. FAR Part 15 is a different story. So as part of the most recent changes to FAR Part 15, it's going to take practitioners and the public some time to get accustomed to the changes that have been made here. So FAR Part 15 pertains to contracting by negotiation. Contracting by negotiation is an area where I spent a lot of time. So a lot of my clients and a lot of the public get involved with the government through FAR Part 15 because it's such a popular way in which the government purchases goods and services. But there have been quite a number of changes to FAR Part 15. Deficiencies, for example, deficiencies used to, in a proposal, deficiencies in a proposal used to mean significant weaknesses or material failures in a proposal. Doesn't mean that anymore. Now it means non-conformance to a material requirement of a proposal. What does that mean? Well, we don't really know just yet because the changes are they've just been issued. And so what it all will mean in practice is up for discussion to a certain extent, but that could be a significant change. Proposal revisions, that's changed. Proposal revisions used to only pertain to changes to material or to any change to a proposal itself. Now it only pertains to material changes to a proposal. That's significant because what is a material change to a proposal? It's going to be up to the discretion of the contracting officer to determine that, unless it could be deemed arbitrary capricious, which, that's the attorney's words. Don't really know exactly yet how that's all going to work in practice. From a 30,000-foot perspective, what it does do is sort of fit within the box of sort of one of the reasons why all these changes are taking place is to provide flexibility to contracting personnel in making procurement-related decisions. And these changes rather to FAR Part 15 seem to fit within that particular box to allow contracting personnel more freedom to request changes to proposals from those contractors that have submitted proposals to the government for a particular opportunity, more flexibility for contracting personnel to enter into negotiations with contractors who have submitted proposals. All of that, all of the changes that we're seeing in connection with FAR Part 15 seem to point to this whole notion of providing additional flexibility to contracting personnel to narrow down the field of potential contractors for an opportunity, and then more flexibility to choose which contractor or contractors will continue on as part of the procurement process if it's multi-phased. And we're going to talk about multi-phasing in a little more detail in a minute, or selecting those contractors or contractor to participate in an opportunity or additional opportunities moving forward if it's a IDIQ situation. So a lot of changes made to FAR Part 15. Here's this reference to flexibility that I just alluded to a few moments ago. You see it identified here. The narrowing down of if it's a best value procurement to a competitive range and how that's done is different based upon the current set of changes. It used to be that there were um, communications that were permissible, required, in fact, of contracting personnel in narrowing down a group of contractors to a competitive range. No longer. There's additional flexibility to contracting personnel in assembling a competitive range. Uh, Now narrowing down that competitive range means identifying those proposals best suited for further negotiation by the government. Again, different. Uh, it doesn't have to necessarily be the most highly rated, and communications that would lead up to a competitive range are no longer required. So you're talking about substantive, substantial differences in how FAR Part 15 once worked versus how it will work moving forward. Based upon the changes to FAR Part 15, it used to be that you had two basic source selection options for contracting personnel. Um, you had best value, which I think I just alluded to, right? Where you have evaluation factors. Past performance is always a factor that would be taken into consideration as part of a best value procurement. And contracting personnel would use those evaluation factors to rate and then select. Price, of course, is always a factor also. LPTA was your second, right? Lowest price technically acceptable, which is not a preferred method and in certain instances shouldn't be used by contracting personnel. So best value using the evaluation factors that I just alluded to is the type of source selection option that would typically be chosen and used. LPTA, though, has survived and is available. Well, now you also have highest technically rated with a fair and reasonable price. That is an additional method that can be used by contracting personnel as part of the changes to FAR Part 15. So what does that mean? So if there's a situation where the government feels as if using the highest technically rated is the most important thing to the government. So for whatever reason, perhaps it's a highly technical purchase that the government feels it's a purchase that requires a high degree of technical specialty, right? So it's super important for the government in a particular instance to have highly rated technical proposal as part of the selection process. As long as the price is also fair and reasonable, then under the new procurement methods of FAR Part 15, if that's used, that's okay, right? Now, how that's going to be used in practice, guess we'll have to see. But it's a new methodology that the government can use as part of the changes made to FAR Part 15. There's also a new phased acquisition methodology that the government can use as part of selecting a proposal for award in connection with FAR Part 15 and negotiated procurements. The government already uses phased acquisition, but the suggestion as part of the FAR Part 15 changes is what we could see is something more substantial than the use of phased acquisitions now. I see them in my practice and have been seeing them in my practice for some time in a construction context where you have design build contracts, for example. So uh, you'll have a phased selection as part of that process, okay? And price would only become something that would be that is taken into consideration as part of phase two. So there might be a design competition of sorts as part of phase one, and it's done different ways. But then there is a winnowing down of the pool of proposals, and whoever survives phase one then goes on to phase two. As part of the revisions to FAR Part 15, they're suggesting that there is that they're moving forward because it's identified as part of FAR Part 15 that the government may use a phased acquisition process. It can use it in a more sort of widespread manner, not just simply design, build, and construction related, but something more widespread. And so that's something that we'll have to see moving forward in terms of how the government decides that it's going to use this new methodology sort of moving forward. FAR Part 16, contract types, an awful lot of the verbiage in FAR Part 16, which identifies all the different potential methodologies or contract types that the government can use and when it should use them, right? A lot of the text has been shifted to the practitioner's album, and the idea behind the changes that we've seen here generally are, again, going back to some of the changes that we just talked about. It's to provide more flexibility to contracting personnel in when it opts to use the type of contract that the contracting officer, the source selection authority, deems the most appropriate under a particular circumstance. So a lot of the quote unquote guidance that was in the FAR under FAR Part 16 previously has been shifted from the FAR itself to the companion guide and or to the practitioner's album. There was a substantive change to FAR Part 16.504, which pertains to IDIQ contracts, indefinite delivery and indefinite quantity contracts, which are max or MATOCs, as it relates to on and off ramping. So as it relates to max multiple award contracts, IDIQs, there's additional flexibility in terms of on-ramping and off-ramping contractors that are on those vehicles. That's been provided as part of the changes to FAR Part 16, and also the use of blanket purchase agreements as part of the MAC process is now permissible as identified in the changes that were made here. So that's a change to take note of. For whatever reason, I don't know why, and you see referred to at the bottom here, the FAR Council doesn't like the word shall, but likes the word, well, shall and may is a little bit different. Shall and must, for whatever reason, they like shall, they don't like must. Here, shall and may is a little bit different. Shall and must is, it's just a choice of words. But as far as the changes to FAR Clause 52 as it relates to, and that's the FAR Part 52, 216-1 is the contract clause that's pertinent to one of them, at least anyway, that's pertinent to FAR Part 16. You do have to pay attention there because there has been a shift from shall to may to make it more discretionary, which means that it's not statutorily based, and there was the discretion to make something even more discretionary, which was done as part of FAR Part 52 here. So something to keep in mind. Moving along, I'm not going to spend a lot of time on FAR Part 17, special contracting methods. Nothing extremely substantive as part of the changes that were made here. Specialty contracting methods when I spend my time here, primarily deals with long-term multi-year contracts and how those should be handled. Again, not a lot of changes here. A few changes as you see. Some guidance has been shifted to the companion guide, not unlike a lot of the other, many of the other FAR provisions that have been altered and changed. Not anything terribly substantive as it relates to multi-year contracting. Okay, a lot of speculation was out there as it relates to FAR Part 19 prior to the changes being issued. There was a concern in the small business world that the rule of two would be eliminated because it's largely, not entirely, but largely regulatory and not statutory. So what the FAR Council did, and they actually made a big deal out of this when the changes were issued, they maintained the rule of two. So any contract issued that's at or below the SAT, the simplified acquisition threshold, it continues to be limited to small business competition as long as there are the rule of two is satisfied. There are at least two small businesses that that are determined through the market research that the government has done as being um, able to perform that particular opportunity. So that was a big deal, and that's been maintained. How it sort of works in practice moving forward, we'll still have to see because there's still a concern in the small business world. I mean, this was a big deal, but there's been some concern about how small business is going to be impacted by a lot of the regulatory changes that have taken place. So it's sort of a to be determined, but the rule of two was retained as part of the regulatory changes here, and that is a big deal. As it relates to uh, multiple award contracts, however, it's very specific in the changes that even under no circumstance is it an obligation or a requirement that the government um, limit, based upon the rule of two, a competition on a task order to small business. So task orders under a MAC do not have to be or are not subject to the rule of two, and that's specifically identified as part of the revisions to the FAR, and that's actually one of the issues, right? So as we gravitate um, more and more toward GWACs and multiple award contracts, the issue of how businesses will be impacted by all of that is still sort of a big question mark, and it will continue to be until we have a better sense of what that impact is going to be moving forward. Another interesting change, it used to be that if a opportunity was within the 8A program specifically, in order for the government to move it outside, that opportunity outside the 8A program, um, it would need to go to the SBA and receive SBA approval for that. That's all internal. It's not public facing, but that's how it works. Not anymore. As long as that opportunity is shifted to another small business program, then there's no longer the need to go back to SBA and receive approval to remove it from the 8A program. So that's an interesting change and something to note as part of the FAR Part 19 changes. You'll see some of the other additional changes that have been performed as it relates to FAR Part 19 alluded to here, some of which I just made reference to. A lot of plain language changes, not inconsistent as compared to changes to other regulatory provisions within the FAR and the other changes that we both talked about and we'll talk about momentarily, but something to make it a little bit easier for the public to read through and understand, in terms of small business and FAR Part 19. Some content has been moved around and shifted. So if you're someone who's been accustomed to going into FAR Part 19 and understanding where you're going to find certain things, you may have to look a little harder because there has been some reshuffling. So that's something to take note of as well. Not a ton to talk about as far as FAR Part 25 is concerned. You see a lot of text here. But the changes to FAR Part 25, which is foreign acquisition, haven't changed a ton. Not surprisingly, as it relates to foreign acquisition, there are a lot of limitations. They're statutorily driven by Buy American and Buy America requirements, right? So those statutory requirements continue to be found as part of FAR Part 25. There is reference to an updated or revised waiver process within the new FAR Part 25, and that's something that's going to be more internally focused as it relates to the government as that gets up and running. But it's something to understand. So, and you see the Made in America office referenced. Uh, office at OMB will be responsible for administering this new centralized waiver process. Haven't heard too much about it. I mean, this is all relatively new. But the idea is to streamline the process, make it easier when waivers are necessary or required. Obviously, the Buy American, Buy America stuff has been very important to this particular administration. So certainly something to keep your eye on. But the substantive changes have been minimal, primarily because of the statutory nature of much of this particular FAR part. FAR Part 27, patents, data, and copyrights. I don't get involved a lot in FAR Part 27. Some of the licensing requirements and issues pertinent to IT and software, I would pay attention to those because there have been some changes as it relates to data rights, and it's actually something that I get involved now anymore with a lot of my colleagues within my firm who do patent and trademark work. And as it relates to the government, it's something, if you operate in that world, the IT software world, and you deal with the government, it's something that you have to pay attention to. I will always drag, my counterparts, as I say, that do that work, patent and trademark work, in to assist with that. But you have to pay attention. If you do work for the government, you have to understand the licensing requirements that pertain to whatever software or IT services that you provide to the government, and understand what rights the government has once those purchases are made. So there are some changes here, things to pay attention to. And if anybody has any questions about this or any of the others, you can certainly reach out to me offline, and I'll answer as many of them as I can. If I can't answer them myself, I will find someone within my orbit who can. Again, a lot of this pertains to software and data rights. And again, as I alluded to a few moments ago, if you're in that world, operate in that world, be super careful about the rights that you're giving away to the government when you sell commercial software or other types of software or IT-related services to the government. FAR Part 36, I'm only putting this in here. I believe I talked about it the last time that I spoke to this particular group. I put it in here because I'm in here all the time. The FAR Part 36 is interesting, only for a lot of reasons, but one of the reasons, at least anyway, is because there is a very large aspect of FAR Part 36 that's statutorily driven through the Brooks Act. That's the architectural engineering side. The other half, as it relates to construction, is not largely. And so a lot of the changes that you see in FAR Part 36 are more on the construction side than you see on the architectural engineering side. And you see various different changes that have been made here, again, primarily pertaining to the purchase of construction-related services, where you have combined design build purchases that are being made. Again, on the design side, you're not seeing a whole lot of changes, but you are seeing it on the construction side. And if anybody, again, has any questions pertaining to these specific changes, I'm in FAR Part 36 quite a bit, and we can spend some time speaking about that offline. I believe, talk about these more specifically when we met the last time. And this was recorded, so you can go ahead and find those comments in the prior recording, or you can just shoot me an email or give me a call. FAR Part 37, as it relates to service contracting, there have been some changes here. There's a continued emphasis within the government on performance-based acquisitions to the maximum extent practicable as it relates to service contracting. There's an awful lot of discussion about PWS's public or performance of work statements as it relates to the purchase of service contracting and FAR Part 37. I was in court yesterday where the PWS and a particular procurement was super important. And we spent a lot of time talking about what it means and was FAR Part 37 followed and that sort of thing. So I do find myself here from time to time as it relates to non-construction related service contracting. Yesterday, we were talking about staffing. It was a staffing contract where the government was purchasing staffing of some sort and whether or not the government appropriately moved a requirement from one IDIQ to another and what it meant, et cetera. But there have not been a lot of substantive changes based upon these revisions as we see here. Some, but not a lot. You do see that very much like other provisions of the FAR, you have a organizational change here based upon the life cycle of a procurement, pre-solicitation, evaluation, award, post-award, again, to make it easier to find things based upon the issue that you may be having and needing to find an answer to. So that's been changed. But a lot of the best practices and a lot of the requirements of FAR Part 37 have not changed. Acquisition of utility services, not something that folks will probably need to concern themselves with. There have been a few changes. They made it a point of excluding utilities or excluding broadband, although it's wonky the way that they worded it. They're probably, as part of the rulemaking process, going to have to go back, but they wanted to exclude broadband from the definition of utility service. So that was at least an attempt at that was done, but otherwise nothing terribly substantive there. On contract administration and auditing services, there have been some substantive changes there. The most important one being how the government handles certain source selection information, specifically contract performance information, so past performance information. It's no longer considered source selection information, which is a little bit weird. So it's not going to be sort of stamped as source selection information internally by the government, which means that your past performance information, once you submit it to the government, the reason that they did this was so that it could be used internally by the government for more broadly, so they could understand companies that do work for the government. Okay, what's their past performance like, across agencies? The problem, of course, is, well, what does that mean? Is if it's no longer source selection information, is it subject to FOIA, Freedom of Information Act, and other folks get their hands on your company's past performance information? Don't know. But that's a significant change to FAR Part 42, depending upon what it actually means in practice. So something to keep in mind. Government property and the use of government property, not anything substantial or substantive here. So not anything to really worry about. Transportation, again, not anything substantively has changed here. Generally speaking, the government wants its contractors to move things on commercial vessels if at all possible and where practicable. That's the sum and substance of what FAR Part 47 is all about. And a lot of the provisions here are statutory anyway. There's a lot of verbiage that was shifted elsewhere, but most of this is statutory. A lot of it's statutory, and the statutory provisions didn't change. And I think this might be the last one here. Extraordinary contract actions. FAR Part 50 is very rarely used. There were no substantive changes to FAR Part 50. So something to, I guess, just take note of. But for even for folks that are in the government procurement world on an everyday basis, you probably never really use FAR Part 50. It came out as something that might be important during COVID, but it wasn't really used all that much. It was talked about, but not really used. Oh, and then forms. Oh, this is actually interesting real quick. So there is going to be a forms database that's created at acquisition.gov where all of the different forms that the government uses will be located. So they've simplified FAR Part 53 significantly, and everything is going to be shifted over to a separate database where all the government's forms will be found. So sort of moving forward, now we're anticipating what's going to happen in phase 2, the rulemaking process. That's coming. I would expect to see things in the Federal Register in the coming weeks. So it's something that I'm certainly going to keep an eye on. And if anybody has any questions as we move forward into that next phase, you can certainly feel free to reach out to me. I'm happy to discuss that with you as it moves forward.